One China deal yesterday. Today we expect that USMCA will be voted on in the Senate, perhaps just a few minutes after this event ends. But one of the key issue that took that agreement over the finish line were the labor provisions in this agreement. They were, I would almost say, revolutionary in the negotiation, and the pieces that were added have taken it to an entirely different level with the labor provisions in this and addressing concerns that have been raised in the original NAFTA. We are delighted to have an expert, really expert panel here today to discuss some of the provisions that helped really change the political dynamics around trade. When you get the AFL-CIO and Teamsters and other organizations coming on board a trade agreement, Ambassador Lighthizer had made that a goal of his, and working with Chairman Neal and his staff, particularly, and the Senate Finance Committee, the Ways and Means Committee, they were able to take this over the finish line and get a really monumental deal with some groundbreaking provisions that I think those of us who've been working in trade for many years never thought we would see. Really thankful to board member Nicole Bivens-Collinson for moderating today's event. Ted Posner, who emailed me a few weeks ago and said we've got to have an event on this. Thank you. Thanks, Carol, Theo, and Ricardo for joining us. Really appreciate your willingness to join us today for this really great discussion. With that, I'll turn it over to Nicole.
Great. Thanks, Ken, and thank all of you. As Ken said, today is a very big day in trade. It's something no one ever thought was possible, but it's a good day, right? So one of the things that Ken said, that there were a lot of changes to the labor provisions, and that really is what took this over the threshold to get people on board. You're still not going to satisfy everyone. There's still some people who just will never vote yes on a free trade agreement. And I think those are the people that have always voted no and are going to vote no again. I don't think it's any indication of whether or not this agreement is good or bad or better or worse, but I think it's just a fact they can't get to yes. Some people just can't do it. I think one of the things we want to think about is, okay, so when is it implemented? Everyone's like, this is great, we're going to get it passed, when's the implementation? We need to look carefully at what those implementation provisions are and when it might happen. And we can speculate all we want up here, but who knows when it will actually happen. And so I think it's a very good time, as Ted brought to our attention, that we need to look at these provisions to see what the differences are. And so that's what we're going to try to do today. And I think you've got to look not just at the provisions that are in the agreement themselves, you've also got to look at the protocol, which was just issued, of course. You need to also look at what is in the implementing bill, because all those together are what's making up the changes. So I'm going to basically give a very skeletal view, outline of some of the things that are in the implementing bill, some of the things that are in the protocol, and then these experts are the ones who are going to really give you an idea. So I'm going to introduce them first, just so you know who we have here. You have in front of you everyone's bios, but just in case you don't know these people, I'll introduce them briefly. Ted Posner, he is a partner in the International Arbitration and Trade Practice at Leo Gottschall and Manges here in the DC office. He's been around for a long time, maybe not as long as me, but he's been around a long time too. But he covers litigation, he's done negotiation, he's an advisor, he does international trade, of course, international trade agreements and investment treaties. And then to his right, your left, is Carol Creer, and she also has a wealth of experience and knowledge in this area. She's currently the Managing Director for International Labor at Impact International, and she helps them with implementing international technical assistance projects, primarily working on strengthening the government and labor law enforcement, and particularly focusing in Mexico. And then to her right, again, your left, is Thea Lee, and some of you have known her as well. She's been around for a long time and kind of, it's the gray hair, we can say this, okay? I can say it. She's a seasoned professional, having done a lot of work formally associated with the, she was the Chief International Economist at the AFL-CIO, and now she is the President of the Economic Policy Institute. And then we have a wonderful guest who I'm so pleased flew up here from Mexico to be with us. This is Ricardo Ramirez. He is a partner of RRH consulting firm, He's also one of the first Mexican and youngest to be appointed to the appellate body of the WTO. Let's hope that the appellate body is around so that maybe you can be the oldest. We will talk about that. But so he's been around since the very first negotiations of NAFTA as well. So again, you can see you have an incredible panel here. So one thing that I would like to draw your attention to, and if I'm correct, Ken, everyone also has a copy of this. If you haven't seen this yet, I think this is a really good synopsis. This is by the Congressional Research Service. This, I think, is, as I said, a good, quick picture of what was and what is. So a lot of people are trying to figure out, all right, what are the differences? What can we see that's most significant? These are the more or less the verbiage of what is different, and I think what we're going to talk about today is what might, in actuality, be the differences and how putting those into place might make some differences. And then so I'm not going to go over that. Y'all read that yourselves. If you look at the implementing bill, there's two things that I want to just bring to your attention in the implementing bill with respect to the forced labor. In this section they're not only addressing forced labor or labor issues with respect to the U.S. Mexico-Canada Agreement, but they're also broadening this on a bigger base. And so I think this is something just for those who are practicing in the labor world to make sure that you didn't miss this, because they're requiring that the President establish an interagency task force within 90 days of enacting the implementing bill. This actually, I think, is a good thing, because what we have seen sometimes in the forced labor world after the TFTA, the Trade Facilitation and Trade Enforcement Act, removed that consumptive demand provision with respect to forced labor, the U.S. Customs Service has been the one that's responsible at the border for patrolling and making sure that those kind of goods don't get in. And what they're doing here is they're going to create a task force that includes not only the CBP folks, but USTR, Department of Labor, Department of State, and the people who have a much more of a knowledge base and experience in the area of what forced labor is. So I think, personally, I think that's going to be helpful. The other thing is the task force, once it's created, has to meet with the committees on the Hill to let them know what's going on. But I think what's important that we noticed is that they're really asking this task force to report on any petitions that are submitted to CBP that have allegations of goods being imported by or with a child or forced labor. And what's key on that is the actual provision on the prohibition of forced labor goods in the United States. It's been forced labor, and then it was child labor, and then there was forced child labor. And basically now we're saying any of that and all of that is forced labor and can be banned. The task force has a bunch of reporting responsibilities, and then we get into the Mexico-specific provisions. And I think one of the things that it notes is that this same task force is supposed to develop, in consultation with the committees, an enforcement plan to look at the goods that may be produced by or with forced labor in Mexico. So again, it's not just necessarily looking at the labor provisions that are in the agreement that have to be done, but it's taking it a little bit step further and focusing on forced labor, which is a little bit more. And then, of course, there's some money that goes to ILAB to help do it. And I think this is something that you'll see that if you look at the provision, specifically sets aside money that would allow professionals up to 5 professionals to be stationed in Mexico to help enforce this. And I think that's something that the Mexicans, maybe Carl talked about that a little bit, were afraid of, is like putting spies in there to watch what they're doing. And then lastly, what we're going to talk about and focus on a lot today is the rapid response labor mechanism. Now this is part of the protocol on the amendments to the USMCA. I don't know that we have supplied a copy of that, but you can go online and grab that easily enough. So we're going to talk about what this requires. It's a creation of this rapid response labor mechanism. It's going to create panelists like they've had in the past. It sets out some very ambitious timelines on how these things are going to move forward. But I'm going to stop there because I want to allow these folks who are the much better experts at it than I am go into some of the details and share with you. Okay.
Well, thank you, Nicole, and thank you, Tawita, for organizing this panel. I'm going to speak for a few minutes about the RRLM, the Rapid Response Labor Mechanism. And I really want to convey two messages to you today. One, this is a big deal. As Ken said, it's revolutionary not just because of the politics, not just because it was the last piece that enabled us to get over the hump to garner sufficient political support in the United States to pass USMCA, but it's really groundbreaking in its approach to dispute settlement. And I'm going to talk a little bit about why. And then I'm going to flag what I see as a handful of implementation issues, issues that the involved parties and the relevant stakeholders are really going to need to wrestle with as they start to make this thing effective. So first let me talk about what it is, just to make sure we're all on the same page. It's important to distinguish the mechanism from the core provisions of the labor chapter. So in USMCA, you have a labor chapter, as you had in most of the post-NAFTA trade agreements. And then you have this thing that was finalized in just a month ago, in December of this past year, that is an annex to the dispute settlement chapter of NAFTA. So it is separate from the dispute settlement chapter itself, from the labor chapter itself. And what does it do? It creates a mechanism whereby a stakeholder in one NAFTA country can complain about the conduct not of a country, but of a particular facility. The term that's used in the annex is a covered facility. So the paradigm here is you have a stakeholder, let's say in the United States, whether it's a union or a producer of goods in the United States that's competing with a good that's traded in Mexico, for example. And it believes that at a particular factory or particular enterprise, a particular facility in Mexico, the labor laws that correspond to core labor rights identified in the USMCA are not being enforced. And here's the key part, here's the kicker. Instead of necessarily complaining about the conduct of the country, here in my example Mexico, for failing to enforce its labor laws, the stakeholder in the United States is complaining about the particular facility. It's a facility-focused mechanism. And what happens when it lodges that complaint? Well, you see, I think everybody should have a diagram, a schematic diagram that I put together. This is not a U.S. government document. This is not an officially endorsed summary. This is my attempt to sort of map out how this process works. You will see that it's quite complicated. The protocol is quite detailed in this regard. I'm not going to try to walk you through it other than to say it begins with an internal process. So in my example, where you have a U.S. complaining stakeholder, it lodges a complaint with this newly created interagency committee, which is a committee consisting of a Department of Labor representative and a USTR representative. It lodges a complaint with that committee. The committee undertakes an internal investigation, and it either decides that the complaint is well-founded or it's not. So it's a yes or no thing. If it decides that it's well-founded, now we're in the world of the agreement. Now USTR is compelled to initiate a process that involves the other party, in my example, Mexico. And here's where things start to get complicated. It tells Mexico that it has a belief that at this particular facility, the law is not being enforced. Mexico undertakes its own investigation, or doesn't. It has a choice, of course. And the parties proceed in this fashion, and there's sort of, the decision tree splits multiple times until either they agree that there is no problem, that if there had been a problem, it's been remediated, or they disagree, in which case they refer the matter to this rapid response panel to deal with it. In a nutshell, that's what this mechanism is about. Why is this a big deal? Why is this revolutionary? Think about the traditional way we approach trade agreement dispute settlement. The traditional paradigm is country A believes that country B is failing to adhere to some obligation in a trade agreement. It initiates consultations with that country. If the consultations fail to resolve the dispute amicably, they refer it to a third-party panel, a sort of adjudicator, to help them come to a state-to-state response to the problem, to try to successfully resolve the problem. That's the usual way we do dispute settlement. Now, there are other models. We have investor-state dispute settlement that many of you are familiar with, where you have an individual investor that's, again, complaining about the conduct of a country, not complaining about a particular company, not complaining about a particular facility. It's complaining about the conduct of a country, and it lodges a complaint with a tribunal to try to get satisfaction and to resolve its complaint that there's been a breach of a treaty obligation. We have a sort of unusual NAFTA particular form of dispute settlement when it comes to anti-dumping and countervailing duty proceedings, wherein you have a determination in an AD/CVD case, and rather than go to, say, the Court of International Trade, you refer to a binational panel. But there, what's going on is you have a panel reviewing the conduct or reviewing an administrative determination by an agency like the Commerce Department or like the ITC that's made findings of fact in the first instance. Here, with this panel, you have this binational panel that is going to be tasked with making findings of fact in the first instance. It is the trier of fact. It will make a determination based on the host country's law. So in my example, based on Mexican statutory law, as to whether a given facility is complying with that statutory law, as to whether the law is being enforced in that country with respect to that particular facility. That is unique. I'm not aware of any circumstance, any trade agreement, any treaty where you have a situation where this ad hoc panel comes together and makes a determination as to whether a particular facility is complying with local law. That's quite remarkable, that this panel gets to make that determination in the first instance. That's new. Another thing that's really unique about this process is that it's very much a complainant-driven process. In other words, if you reach the point where the internal investigation has completed, and again, in my example, the U.S. government has formed a belief that there's been a denial of rights, it drives the process forward. Yes, there's consultation. Yes, of course, the United States is talking to Mexico along the way in this paradigm. But if the complainant, here the United States, believes that the problem is not being resolved in an adequate way, it drives the process forward up until the ultimate stage here, which is the penalty stage, where you've gone through all the different steps in this decision tree, and the complaining party, here the United States, has come to a view that the problem at this particular facility is not being remediated. Rather than go to the panel and say to the panel, do I have permission to impose tariffs or other penalties to remediate this problem, the United States gets to do it on its own initiative. And if the respondent party here in Mexico believes that the United States has stepped out of bounds, has imposed a disproportionate penalty, it's the respondent that has the obligation to go to the panel to seek a solution. That too is quite remarkable. I see I have a minute remaining. Let me quickly just flag what I see as some key implementation issues. The core event in this entire process is that this panel has to undertake a verification. The parties have been unable to agree as to whether there's been a denial of rights at a particular facility. The panel now, in theory, goes down into Mexico to visit the facility and does what? And that's not stated in the protocol, and there seems to be a real tension between, on the one hand, the desire that this process be rapid. It's called a rapid response mechanism. So there's a desire that it be rapid, and at the same time, the issues that it's dealing with are very weighty issues. Does it get to interview witnesses? Is it looking at documents? Will local courts aid it in its attempt to find facts? What kind of rules of evidence apply? So there's a lot of procedural, due process-y type questions that I think are left unanswered and that are very much in tension with the desire that this be a rapid process. One last point, and that concerns remedies. So the ultimate remedy here is there's a denial of rights, the parties are unable to agree on that, the complaining party decides to impose a remedy, and what is that remedy? You would think ordinarily it would be a suspension of preferential tariff treatment, but what if the facility in question is producing a good that's not traded? Or what if it's producing a good that is an input into a good that is traded? Or what if it's a provider of services? So there are a lot of open questions as to how this penalty is supposed to work and what the guardrails are around the penalty process. I hope we'll get a chance to talk about that more in discussion. Appreciate your attention, and I'll pass the mic over to Carol. Oh, not to Carol. Okay.
Don't give me that one.
Okay.
I gotta make sure we stay on task. So, Carol, please.
Okay, thanks. I wanted to take a step back before diving into what I see as some of the kind of big picture operational challenges. Ted did a really great job of laying out what the rapid response mechanism looks like and some of the finer points of the operational challenges. But I want to take a step back because although this is incredibly groundbreaking and revolutionary, as Ted said, this is not by any means the first time that we have thought about the concept of trying to hold private sector actors accountable for workers' rights violations in the context of trade. I mean, these discussions began decades ago, and you've seen it play out a bit more in the unilateral trade preference program structure. I mean, think back to the U.S. Textile Agreement before MFA was phased out, where increased market access was granted to Cambodian textile and apparel companies who were found to be complying with labor laws and labor standards. HOPE 2, the preference program for Haiti's textile and apparel sector, which similarly requires that producers comply with core labor standards and the labor laws of Haiti in order to get preferential access to U.S. markets under the unilateral trade preference program. I mean, the difference in those cases, a number of differences, obviously. One is unilateral, so it's not a state-to-state agreement. It's a U.S. law providing preferential access. Two, it's a particular sector. And I think that has always been one of the conceptual challenges that those of us who've been thinking about this for a long time have grappled with, is how to take this, countrywide. So in both cases, you were looking at textiles and apparel. And in both cases, the sectors were relatively small. I mean, if you think of the Haitian textile and apparel sector, you can count the number of factories, which then leads to the third point, is that it was relatively, I wouldn't say easy, but it was manageable to actually monitor the different factories. And in both cases, we had ILO-managed programs. In the case of Cambodia, it was a program that was a precursor to Better Work, the Garment Sector Working Condition Improvement Project. And in the case of Haiti, it was essentially the Better Work program. So you had the ILO that was conducting monitoring visits of the factories and producing quarterly reports that assessed compliance with the local labor laws and international standards. So fast forward to discussions about how to do this in the context of a free trade agreement, and Ted mentioned the different challenges, the state-to-state nature of the agreement being the biggest one. And those discussions had previously taken place in the context of dispute settlement. How can we try to tailor any remedy if we ever got to an arbitral panel decision in a labor case? How could we tailor a remedy so that the factories that were implicated in a particular claim actually felt some of the consequences, and ideally some of the workers involved in these cases were able to benefit from some of the remedies. Some of the ideas that were batted around, we all know that the instruction for a country was to try to target seek to suspend benefits in the same sector or sectors affected. There were discussions about whether maybe we should take that one level down and try to target the sanctions at a particular company that was implicated in the case. But these never really went anywhere, which I think is why it is so impressive that now we have this rapid response mechanism. So that's kind of a little historical, very quick historical context of some of the thinking that has gone on for many years to try to get to the point where we are today. Operational challenges. With anything that is new like this, that has so many different, really innovative, I think, aspects, there are going to be operational challenges. And I just want to talk about a few of the bigger ones that jump out at me immediately. One point of clarification off the bat, the rapid response mechanism is actually can only be triggered if there are allegations of violations of freedom of association collective bargaining laws. So it doesn't cover all of the core labor standards that are covered in the labor chapter. Instead, it covers the laws that are adopted by Mexico to implement Annex 23A, and Annex 23A is on collective bargaining. It's the implementing legislation for the constitutional labor justice reforms that occurred a number of years ago. So that is kind of one of the limitations of this. There is a caveat to that, and I'll get to the challenges in a minute. The caveat to that is a really cool provision in the protocol that I actually missed the first time I read it, which is the expansion of rights provision, which states that if there is an arbitral panel finding against a responding party with respect to the labor obligations of the labor chapter, then you can expand this rapid response mechanism to cover rights in addition to collective bargaining and freedom of association, discrimination, forced labor, child labor. So that would be the instance in which the rapid response mechanism could be used to cover the other rights that are protected under the labor chapter, not just collective bargaining and freedom of association. So diving in a minute to the operational challenges, the first one that jumps out at me immediately is I was struggling to conceptualize how this would relate to the Mexican domestic labor law enforcement process. Mexico is establishing an entirely new labor justice system. That is what these laws that are implemented under Annex 23 are going to be doing. They're implementing constitutional labor justice reforms that were passed in 2017, abolishing the conciliation arbitration boards that for around 100 years were the key mechanism to enforce most Mexican labor laws, establishing for the first time ever labor courts. How is this process going to intersect with that? As Ted mentioned, a complaining party then submits a request to the responding party, Mexico in this hypothetical, to conduct a review. Review within 45 days to determine whether the alleged denial of rights at the covered facility occurred, and if it occurred, to try to remedy the problem within 45 days. Who is going to do this in Mexico? Is it the labor inspectors? Is there going to be some kind of expedited process that is going to be established at these new labor courts, which haven't even been set up yet? If there is a finding that there was a denial of rights, how does that then feed into any subsequent domestic labor process that might start? Or is the remedy that is going to be recommended or imposed going to be the remedy that would be called for under Mexican law if the particular right alleged to have been violated is violated? And then Mexico has a unique situation in which certain sectors are covered by federal institutions and other sectors are covered by state-level institutions. The Constitution enumerates 22 sectors that are covered by federal inspectors and federal courts. The rest are covered by state-level courts and state-level inspectors. So there is a scenario in which the sector under which this allegation of denial of rights, in which it occurs, may be a state-level sector. So how do we manage that process? Are there different actors in Mexico who are going to be conducting the investigation if it's a sector that naturally falls under state-level jurisdiction? And these are all kind of different things that we're going to need to be figuring out. And from Mexico's side, as they are struggling to establish an entirely new labor justice system, which is a monstrous undertaking, they are also going to have to figure out how to establish another process that responds to this rapid response mechanism.